Good afternoon, and thank you very much for being here. My name is David Nachman. I'm a business immigration lawyer. I'm from the NPZ Law Group, which is a immigration law firm with offices located in Ridgewood, New Jersey. We also have an office in Branchburg, and we also have offices in New York with affiliated offices in Canada and in India. And this afternoon, it gives me great pleasure to be back here with the HRM group, SHRM group, yes. Tri-State here in Mount Laurel. And I have an opportunity to chat a little bit with you about what's going on in the immigration enforcement world. This is of particular interest, of course, to human resource managers and human resource professionals who are responsible for the I-9 form at their organizations, because one of the things that, and we'll go to the first slide, one of the things that everybody needs to know is that when President Trump came into office, he instituted a program or a policy called BAHA. BAHA is Buy American, Hire American, and subsumed within that policy are things like increasing enforcement. You all know about the wall, and obviously additional steps have been taken to try to get funding for that wall. Lord knows how that's going to go, we'll see. But what we figured out is that there is actually an invisible wall that's being created. And that invisible wall is being created through things like the slowdown of processing of visas and an increase of enforcement and a very deep increase of scrutiny that's going on with regard to applications that are being filed with the government. So, so what BAHA is all about is prioritizing jobs, wages, and security of Americans, okay? And that's really the heart of it. But what it really stands for and what we're seeing is increases in worksite enforcement. We're seeing extreme scrutiny on the H-1B side. So for those of you who are responsible for H-1B non-immigrant work visas, you have probably already experienced these long RFE, request for evidence, documents, and even our public corporations are being asked to prove that they're able to do business, which of course is insanity, but this is what's going on in today's world. Also, there seems to be a step up and a move toward E-Verify, and obviously there's a lot of discussion about E-Verify. E-Verify is a program. E-Verify is an electronic vote program. Generally, it's voluntary. However, there are certain things that force employers into E-Verify. One of them, of course, is granting STEM extensions to international students. Another is that there are certain states that do require it, and if there are government contracts, that also might require an employer to go into the E-Verify program. So that's another piece of this BAHA. What's really kind of interesting, we just take a step back. It's sort of interesting to see where we are now, because where all of this enforcement stuff comes from is a law called IRCA, the Immigration Reform and Control Act, which was implemented back in 1986. And I'll just remind everyone in the room that that was implemented under a Republican president. And I know that we have a lot of issues, of course, with maybe the Republican administration. I'm not speaking for everyone, but some people do. But I will remind everyone that the best immigration laws have in the past been passed under Republican presidents. So maybe there's some hope for us after all. We don't know, of course, but we'll see how that goes. And what also we've seen is an increase in removals and deportation, and we've also seen an increase on the number of ICE officers who have been hired to, of course, enforce the immigration laws. So from the inception of the new administration, a couple of things that we've seen is, number one, we've seen worksite raids. Worksite raids were something that it was fairly common in the early 90s, where buses would pull up and individuals would be put on the buses and taken away. Now we're starting to see that actually happen more and more. There was just recently a report about a company down in Texas where they did that. So There are certain targeted organizations. The government runs all kinds of special programs. They ran a program called Operation Tarmac, where they were going after people who were cleaning at the airports. But car washes, meatpacking plants, fruit suppliers, these are the types of organizations that they are going after. But the focus in terms of enforcement seems to be on individuals who have previously been removed or people who have criminal records. So that's where the focus seems to be. So they're using whatever databases are available to them to be able to take care of that. So we're seeing vigorous enforcement, especially in some certain states, California, New York, New Jersey, and of course along the southern border where these issues seem to be prevalent. There's also an increase in penalties, and we will make reference further on to a penalty grid which shows how the penalties can be stepped up depending upon the number of violations. Okay? So, as I said, in 1986, it was actually in November of 1986, the government passed what's called IRCA, the Immigration Reform and Control Act, and that was what made employers the watchdogs and also made employers responsible to ensure that individuals have work authorization and show the proper documentation to do the I-9 form. So what happens after the I-9 form comes in? The government doesn't just set it and forget it. It doesn't work that way. The government actually goes back and studies what happens after a law is implemented. That's what the Office of Management and Budget is for, or the GAO, the Government Accounting Office. They take a look at what the law is about. And one of the things they found out after IRCA came in is that employers got scared and they didn't know what to do. So employers were like, show me a green card. Well, what's that? You know that. That's document abuse. So you can't do that. So they tried to fix that. What did they fix that with? They fixed that with discrimination provisions. So you're not allowed to discriminate on the basis of citizenship and nationality. That's illegal. And then what else happened? Individuals, when they realized they had to show documents, went out on the street and bought them. Okay, and then they showed fake documents, and what happened in 1991 was the government said, oh, we need a document fraud provision, where what we can do is we can turn to people who are showing fraudulent documents or employers who are taking fraudulent documents and to bring actions against them. So that's what the document fraud provisions are. So as we march slowly into the 90s, again, what happens is we see some changes over time, but basically what IRCA requires is that new employees, and that's all employees in all organizations, have to show documentation that they're eligible to work and that their identity has to match the work eligibility documents, and that basically the standard is this. There's an objective and a subjective piece of it, okay? The documents have to be genuine on their face. Genuine on their face is the subjective determination that they are reasonable on their face. And reasonability is for you to determine because you are the reasonable person. And then the documents have to refer or relate to the individual showing them, which means that if a person comes in front of you and shows a document that says that they're 250 pounds and they look like they're only 90 pounds, then you should say, there's something wrong with the biometrics there. I don't know whether that is correct. Please show me another document. You have the right to do that. So there are two components to this. Genuine on their face and refer or relate to the individual showing them. And that's a very important thing for HR professionals to understand. There are sanctions for paperwork violations and document abuse. There are also sanctions for knowingly hiring and retaining unauthorized workers. And yes, and in terms of discrimination, a new organization was formed back in the day. It was called the Office of Special Counsel for Unfair Immigration-Related Employment Practices. That organization is part of the U.S. Department of Justice. It's now referred to as the IER. Okay. Good. So, employers who violate the law, this is something really important, is that under I-9 penalties, you can get civil fines, you can get criminal penalties, you can get debarred from government contracts. And for a lot of corporations, that's really bad because a lot of organizations rely upon government contracts. Okay, you can also, there could be a court order requiring back pay. You could also have a court order that requires the individual to be rehired if they're discriminated against. Oftentimes that's either done by the EEOC or it's done by the IER, again, part of the Department of Justice. And one of the ones that we're seeing now, which is brought by the U.S. Attorney's Office, is harboring, where if an individual, let's say, provides housing or wages to an individual who's not authorized to work in the United States, they can be charged with harboring. And Immigration Customs Enforcement, they're very good about using the criminal statutes as leverage to be able to get the results that they need in a particular case. We've actually seen cases where they've alleged debarment, and that's really bad. Again, for a company that's doing government contracting and wholly reliant upon government contracts, taking away the government contracts could basically put the business, put them out of business. So quite a bit of leverage. Mm-hmm. What you're looking at here is the anatomy of a typical I-9 form worksite investigation. The way it would happen is that the Immigration Customs Enforcement officer will come to the site. What they'll do is they'll give you a notice of inspection. Within 3 days, you have to show the I-9 forms. So all the I-9 forms for all the employees have to be shown. The way you would figure out who are those employees is you do a payroll run. And you can match up the I-9s against that payroll run to ensure that you have it for everyone. Now, just as an aside, there are some folks who are exempt from I-9s that don't have to do I-9s. One of those groups is individuals who were hired before November 7th of 1986. They're called grandfathered. You also have individuals who are performing sporadic or intermittent domestic work. So the kid who comes down the street and cuts your grass, or the person who helps you to clean out your attic, those are people who would be exempt. You also have independent contractors, but they have to be true independent contractors. So that's a bit of a sticky thicket that we got into with the Walmart case, is are they truly independent contractors, or did the employers know that they were not authorized to work and send them down the street to be hired by a staffing agency and then leased back? Because that is not allowed. That's what we call an end run around the law, and we don't want that to happen. So again, what happens is the notice of inspection is served. They inspect the I-9 forms. If they inspect, they usually run all the names through a system called SSVNS. It's an ancillary type of a database to the Social Security Administration's database. And then what happens is that if there are discrepancies, they come out with those discrepancies. And then if there are documents that they look at that are suspect documents, they give the employer a notice of suspect documents. Basically, this part of the process is like an accelerated Social Security mismatched letter type of a scenario where they're saying, okay, we have a problem with these folks, deal with it. So what you're supposed to do as an employer is basically give notification to the individual. There's a discrepancy. Immigration Customs Enforcement has found this discrepancy, and then they send the individual to Social Security Administration. Well, the employer should send the person, and then they have to come back with better documents, real documents, hopefully. If there are violations, employers can be held for, then there's a distinction between the types of violations there are substantive violations, technical violations, and then, of course, depending upon the types of violations, it leads to either warnings or notices of intent to fine. If the employer is served with a notice of intent to fine, then that usually is a situation where the lawyer is brought in, and then we work with the employer to try to help them to mitigate the penalties if we're able to do so. And then, of course, it can lead to ultimately compliance, a settlement with the counsel for the Immigration Customs Enforcement, or you could go on and litigate the case before the Office of Chief Administrative Hearing Officer, which is down in Washington, D.C. So that's how some of these things can shake out. Okay? So this is just a list of some of the fines and some of the penalties that you could be held for. Okay, and obviously what I think is important is to see that there's a first offense, second offense, and third offense levels, and they're stepped up as you go. And what's also interesting is that the government, they do come back. So, and they come back after, usually what they do is they come back after a year or two. And I think that they want to make sure the employer is actually complying with what they have told them to do. And they also know that if they haven't, they're going to slap them on the wrist double for some of the things that they've done. So knowingly hiring, failing to comply, committing or participating in document fraud, that was that 1991 provision. Committing document abuse, don't tell people what documents to show, give them the list. Okay, discrimination, and then failing to notify DHS of a final non-confirmation. That's connected to the E-Verify program. So that's important. Most people don't realize that. Okay. And then, of course, there are the criminal penalties. So the criminal penalties are for engaging in pattern and practice. And there's a well-developed, semi-well-developed body of law that describes what is considered to be a pattern of practice. Okay. So these are some of the changes that occurred after the Immigration Reform and Control Act. Basically what they do is they pared down on the number of documents that are required. So they pared back on certificates of citizenship, naturalization, re-entry permits, and refugee travel documents. They did that in 1997. The reason why is because those documents were very susceptible to fraud. I could probably make those documents better on my computer than the government makes them. So they said, you know something, we shouldn't let these be out there. It was then again rebranded in 2007. It was updated in 2009, and now we have the new smart form. So I think the next slide is about the smart form. Okay, and so this is the form that you should be using. It's the most up-to-date form, and what we'll do is we will do another video, maybe from here later on, about what the smart form is all about. So thanks very much for your attention. Thank you very much for being here, and I appreciate, if there are any questions at all, feel free to obviously reach out. Thanks so much.